SJC-10917, Commonwealth versus Morales.
Kelly, good morning.
Good morning, Your Honors. If it please the court, excuse me. I'll try not to do that. If it please the court, my name is Brian Kelly. I represent Ariel Morales for today. Your Honor, there's one issue in this particular case, and it has to do with the prior consistent statement. And the issue is whether the trial judge was incorrect, or at least because there was no objection, of course, that there was a substantial likelihood of a miscarriage of justice by allowing a police officer to come back in and basically recite the testimony of probably the most damning witness in this particular case. I would suggest to Your Honors that although the case law over the years, starting way back with the Tucker case back in 02, I think it was, 05, all the way up to Caruso in 17, has watered down the admissibility or the inadmissibility of prior consistent statements. And I would suggest that in this particular case, respectfully, trial judge made an assumption, and I think the assumption follows through with the argument that's been made in the Commonwealth's brief, that the defense counsel was going to impeach this particular witness, Mr. Perez, Jose Perez, Pinchon, they call him, with the fact that he had a plea deal.
Let me ask you just...
Yes, Your Honor.
I know that's the argument, but why isn't it enough that the defense counsel brought up in opening statements the fact that Perez Pinchon was going to be an issue, his credibility was going to be an issue, and then obviously there was cross-examination of his credibility. So why wasn't that enough to be able to introduce the prior consistent statement?
Thank you, Your Honor. As to that issue, I have a couple of points to make. First, it should be pointed out that this plea, if you want to call it a plea deal, for lack of a better word, was initially brought up on the Commonwealth's opening statement. Then a follow-up was the defense attorney's opening statement. And I would like to call the court's attention, I know you've read it, but I just think it's kind of important, in that the only thing that was actually said, the Commonwealth's opening statement went for about 14 pages of transcript, the defense counsel went for 3. But the only thing that was actually said by defense counsel with reference to Mr. Perez was Jose Perez cut a deal to blame someone else for what he did. He did say that. And then after defense counsel mentions all the other players, Jose Perez, Luis Canones, Danny Barr, Christian Delaney, he says, keep in mind what people's motives are to say what they're saying. That's the entirety of the opening statement that has anything to do with Mr. Perez. I would suggest that that does not fit the bill, Your Honor, as the Commonwealth argues on page 20 of its brief, that the opening statement introduced the theory that Jose Perez's trial testimony would be falsified as a recent contrivance. I would argue that what I just read to you of the actual verbiage of the opening statement doesn't rise to what that said. I would argue that way.
Well, he said he cut a deal to blame somebody else for what he did. So does not that suggest that the deal is what shaped his testimony?
I would argue, I wouldn't totally disagree with you, Your Honor, but I would say to you that in every case, I would think, I mean, certainly deals are made all the time in both civil and criminal cases. I mean, they settle cases, they plea out to cases to get a better sentence, more favorable. And in this particular case, I would say, while you're absolutely correct, Your Honor, it just doesn't seem to rise to the level of what the Commonwealth has argued as this, he falsified. He just said he cut a deal, and deals are cut all the time. So I would suggest, Your Honor, that it's probably, I don't think it rises to that level of characterization, if you will.
What about that Judge Sanders, before allowing this evidence in, didn't make the determinations of a preliminary question of fact upon which admissibility depends as to the two requirements for a prior consistent statement? The Commonwealth says that her findings are implicit in allowing the evidence in, but she doesn't actually make the findings of fact that are required, that it's recent fabrication, improper influence of motive, or rebuts the claim of bias, and that the statement preceded the fabrication or improper influence or bias.
Yes, Your Honor. Well, I would suggest to you, Your Honor, that it even goes a little further than that. I know that the recent cases, I think Caruso is the latest in the line of these cases, which basically says that a judge no longer has to make a finding. It's now an implicit finding. Which
I don't think it says that. I don't think it says that. You have to make a finding. You can't, Judge Sanders cannot be criticized because of Russo. Russo was probably 10 years after this case. But no, it does, the judge has to make findings under 104A as a preliminary question of fact. That didn't happen here.
Well,
and what Caruso says, this is to your benefit.
Yep.
What Caruso says is that there are circumstances that allow the findings to be determined implicitly. It doesn't excuse making the findings.
You stated it much better than I did, Your Honor. But I think actually in this particular case, it could be argued, and you may be thinking I'm arguing against myself, but I'm not. It could be argued that the judge actually did make a finding. And my contention is that if that's found, I believe the judge respectfully was incorrect. Because what the judge said just prior to, the judge gave an interim instruction just prior to Trooper Russell getting up to testify. She had said, there was a discussion between counsel and the judge in which it almost seemed like everyone kind of just assumed that we're going to be letting in prior consistent statements. But what the judge said, Your Honor, if I may, she said, certainly, she said to the jury, I'm going to allow Trooper Russell to give a statement. And she said, certainly on cross-examination, his, meaning Mr. Perez's, credibility was attacked, called into question, particularly with respect to a plea agreement that had been reached with the government. That's what she actually said. And I would suggest to the panel that that was incorrect, because although because actually the cross-examination of Mr. Perez was as to any type of deal or agreement were three questions, and actually really only one. The questions were, do you know you were charged with murder? Yes. Do you know what murder carries for a sentence? Life without parole. And the final question is, and subsequently you entered into an agreement to testify and reduce your sentence to 5 to 7 years. That was the entirety of any cross-examination of Mr. Perez regarding any type of thing that I could say would be a recent contrivance. Now the rest of the cross-examination hit 7 points.
But wait, I'm sorry.
Yes, Your Honor.
Just before you leave
Yeah,
that.
no, please.
Isn't that enough? I mean, asking about the plea agreement, isn't the point of asking about the fact that he was charged with murder, the fact that it carries life without parole, and the fact that he entered into an agreement? The purpose of those questions are to question his credibility, no?
Well, your point, of course, is valid, Your Honor. But what I purposely did this, and I don't know if it was correct or not correct, but I mean, I'm not trying to pull anything off on a panel like this, but I included with the brief an appendix of what had happened in the sister case. to this with co-defendant Luis Lopez. And I did that for the purpose that I don't think I would ever find a situation where I've got the exact same facts, the exact same witness, the exact same judge, and as the panel can see, if it was something that was acceptable to read, as I obviously tried to qualify that I was putting that in not for any purposes of argument, but just to show what the difference was of the extensive cross-examination that was done on Mr. Lopez by Mr. Lopez's attorney.
Putting that aside for just
Yes,
a
Your
moment,
Honor.
the judge said that his credibility was attacked. And sure enough, with those 3 questions, his credibility was attacked.
Well, I would suggest, Your Honor, that it was a statement of fact, and I don't necessarily know. He said there was nothing there that said, and like Mr. Lopez's case, and you would do anything to get out of this, wouldn't you? You'd lie to get out of this. You'd tell nothing.
I mean,
All he
you
stated.
can do it. You can do it. The trial counsel has an opportunity to try the case as he or she sees fit. But in this particular case, that's how it was done. Those questions for the purposes of attacking credibility. So I understand you're saying it could have been done more robustly, but nevertheless, credibility was attacked, and the judge pointed out that his credibility was attacked.
Well, I would respectfully, Your Honor, disagree that it was the credibility that was attacked. It was just matters of fact.
Why would you ask it, though? Why would you ask the question if you didn't want to attack his credibility? What's the reason for the question? Those 3 questions.
Again, obviously I can't know why, but I will
You're
say.
saying that they weren't for the purposes of attacking credibility, so you must have some insight as to what they were then for.
Well, if it was to attack credibility, Your Honor, again, I'm not a trial counsel, but I would say it was done very inarticulately.
You're saying it wasn't enough.
Effectively.
You're saying it wasn't enough under the cases, whereas in the companion case it was.
Well, yes, Your Honor, because at this point, as you know, and as I've kind of tracked these cases in my research, as how over the years the exceptions to the allowance of prior consistent statements have gone along, from sometimes they use the word it was implicit and things like that. I would suggest that at this point, if the only thing that now, if we got one question, if that is enough, then I would suggest then probably the rule has watered down to the point where if we have a case where a key witness has a plea, then prior consistent statements are always admissible.
Mr. Kelly, you've only got to work with what you have, and I think that it's an argument worth making. I think the challenge of it, though, is just as Bud just alluded to. The opening says cut a deal with the police and blame someone else, and the cross is cogent. Sometimes less is more, and the thrust of the cross is that you're getting a substantially shorter sentence because you entered into this agreement. And what the Commonwealth wants to show, not for its truth, but to corroborate, is before he cut a deal, before he had a substantially shorter sentence, when the police said, we can't promise you anything, we're not going to give you anything right now, we can't promise you anything, he said something similar to what he said at trial, which was prior to the deal that is being used to impeach the witness.
Right.
Now, I appreciate that. I think you're making this as a 33E argument.
Correct, Your Honor.
And saying, as Justice Link suggested, could have been done a lot better, wasn't really a lot there, and maybe that's substantial likelihood, I don't know, but it was to impeach to some extent.
Well, the only thing that I can suggest to you, Your Honor, in response to that, is that what the defense counsel said in opening, and more importantly in those 3 questions, was nothing more than what had already been revealed to the jury by the prosecutor in both her opening statement and her own direct examination of Mr. Perez. Basically, on the opening statement of the Commonwealth, if I may, Your Honor, the statement was, and what you'll hear that subsequent to Mr. Perez telling what happened, ultimately he agreed that he would come in to testify. And you will hear, in fact, that in exchange for him coming and testifying, that he will get an agreement that he will receive a sentence of 5 to 6 on accessory after murder. So essentially, the cat's already out of the bag. And as I suggested, and I don't know how this argument went over with the court, but as I suggested, it's kind of a corollary to that Mosby case when the Commonwealth comes in and objects to some evidence coming in, and they wind up excluding it, and then come back in and tell the jury, well, they didn't bring this up. Same thing. Is it a fairness for the Commonwealth to come in and on opening statement and on the direct examination of this key witness to mention the plea, and then when defense counsel gets up and says one sentence, and you entered into agreement to reduce it to 5 to 7, which was just a reiteration of what had been told prior, is that fair to then say, okay, the defense counsel opened the door and is challenging the credibility of this key witness? And the whole point about why this is so important, Your Honor, is this case, I mean, it was a horrific case. There was no forensics on this case. And Mr. Perez's testimony was damning as that gets. It was him. This whole case hinged on him. And
But there was the other friend, too. What was his name, DeLeon?
well, the DeLeon hid the gun and all this, but it's still, at that point, Your Honor, that was all about, okay, come, take the gun, hide the car, clean the car. We have bullets, smash the gun. Well, it was all directed, but at that point, it still was not, it still could be argued it wasn't clear as to who actually pulled the trigger. The only one that puts Ariel Morales as the trigger man who shoots the man 12 times was Mr. Perez, Jose Perez, and completely damning. But the question then becomes, and I call the court's attention to both the Tucker and the Darden case, which question, even with the instructions by the judge to the jury, that it certainly could give the jury, they could mistakenly or even maybe just naturally take that for the substantive use, almost as corroboration as opposed to just a credibility issue.
Yeah, I mean, it seems as if the gist of your argument is there are two ways for defense attorneys to approach this type of a matter. The spare cross, which was what was used here, and the more aggressive cross, which was used in the Lopez case.
Correct, Your Honor.
But ultimately, the reason why a defense attorney may choose a spare approach is to basically say, I've got all I need for ammunition for my closing. So if you basically say if the defense attorney maintains a spare approach and that will keep out the prior consistent, there's nothing that bars defense counsel then from essentially using that in closing as the basis that this guy had an enormous incentive to lie, and he could make all the same arguments with a spare approach as he could have with the aggressive approach. It just meant that he may have made a strategy to say, why risk the person coming back at me? I've got what I need, and I'll use it on closing. So do we want to have a jurisprudence in which the spare approach will result in the prior consistent not coming in, and the aggressive approach will result in it coming in?
Well, again, and I will be honest with you, Judge, right now, I can't tell you, I would be lying to you if I told you what the closing was. I don't, right off the top of my head right now, I can't, I'm not going to make a representation and, oh, we never said anything in closing. I would not do that to this court. But the point that I am trying to make is that the trial judge went on record and said, his credibility was attacked, particularly with respect to a plea agreement. And again, without beating a dead horse here, Your Honor, I would suggest that if that is enough, that one sentence is enough. I mean, it seems like everybody was anticipating that this would happen. It was that, everyone was anticipating this guy's going to go and just cross-examine Mr. Perez and attack his credibility. But he never did. And in this particular case, when the interim instruction by the judge prior to bringing up the trooper already heard what the cross-examination was, as innocuous as it was, I just don't think that would give the court, the trial court, that sufficient basis to now say, okay, we'll let in prior consistent statements. As I said, otherwise, I would suggest to the court that the rule now just gets watered down to the point of, if there's a plea, prior consistent, all somebody does have to do is, say the magic word, and it comes down, and that's it. And unless the court has any further questions, I'll rest on the rest of my brief.
All right, thank you.
Thank you, Your Honors.
Ms. Cusick.
Good morning, Your Honors. May it please the Court. Tracy Cusick for the Commonwealth. Commonwealth is asking this court to affirm the conviction for the murder of Carlos Carlito Gomez. Your Honor, in this case, the issue of the plea was actually brought up in voir dire of the Venere. The judge did ask a question about whether people had any thoughts about witnesses who had agreements with the government, to suggest it was actually sooner than the time of opening statement. This was not a surprise from the reading of the record that defense counsel didn't realize this was a topic. Certainly everybody involved in the case clearly was aware that this was where this was heading. Your Honors, with respect to the judge's decision to admit the testimony of Trooper Russell, I suggest it is implicit in the way the case proceeded. There was a discussion of the instruction prior to the trooper testifying. So where there was that discussion of the instruction, it was not something where the testimony came in and then the judge made some after-the-fact decision that it was properly admitted. It was clearly admitted after an extensive discussion of what instruction to give. So suggest there was nothing wrong there. Your Honors, with respect to the plea, that was not the only thing that happened during the examination of Mr. Perez. He was challenged repeatedly about what he told the police, what he had said to the police, about apparent inconsistencies in his prior statements to police. It was not just the fact that he had entered into an arrangement with the government that prompted the judge to permit the testimony from the trooper as to the prior consistent statement.
How does that help, though? I mean, the prior consistent statement can't come in because somebody's been impeached. I mean, it can under the federal rule. There was an amendment in 2014 of the federal rule, but it can't come in just because it impeaches, and then there's rehabilitation. The rehabilitation of the prior consistent statement requires that it be before some suggestion of a recent fabrication, improper influence of motive, contrivance, or a bias. And if the impeachment doesn't suggest any of those, and the statement wasn't before any, or the statement wasn't before any of those, the fact that it just happens to be impeachment doesn't get you to a prior consistent statement.
No, Your Honor, but here it was implied that the fact that this witness had entered into the agreement was the event that caused.
I understand, but what I guess I'm just asking, what is the fact that he was also impeached with other things due to help the prior consistent statement argument?
Well, Your Honor, in terms of this case, it's certainly not just there happens to be an arrangement made with a witness is not the only thing that was going on with the cross-examination of Mr. Perez. So just that is certainly the fact that trial counsel was suggesting was the bias or was the triggering event.
Right, so I guess my point is if the plea agreement hadn't come up, this other cross-examination that to impeach Mr. Perez wouldn't have gotten you to a prior consistent statement.
I agree, Your Honor. And here certainly there was no motion in limine. Nobody sought to prevent that from coming in. It seems like both sides wanted it in. Again, the defense to say, don't believe this witness because of this arrangement. and from the prosecutor's perspective, introducing it in the case in chief rather than not knowing what the defense was going to do with it.
In this case, though, didn't Perez have a motive to lie all along, you know, even before he entered into a plea agreement? So why does the plea agreement make it special, make it a recent you know, and the idea there could have been a recent contrivance?
Your Honor, reading the record, I don't agree that he had a motive to lie prior to what the plea agreement. When he spoke to the police told him, we can't offer you anything. All he was looking for was protection from the defendant and Lopez. He was afraid that they were going to kill him. So certainly he told the police things about his involvement in this matter that certainly were incriminating as to him. So I suggest here the suggested bias was the plea arrangement with the government.
The accessory after the fact that he pled guilty to, what did the Commonwealth say he did that justified a conviction for accessory after the fact?
Your Honor, I wasn't at the hearing on that, so looking at the record, it seems here he was in the car, he was...
Well, in the car wouldn't be accessory after the fact.
He was also present during when Mr. De Leon showed up and took the bullets, but most importantly, when Mr. Perez first spoke to the police, he lied about not knowing the victim. He said he didn't know a Carlito or he knew many Carlitos. He was not honest with the police at that point in time.
So his 5 to 7 years comes because he initially lied before he came clean?
Your Honor, again, I wasn't present for what was exactly said, so I don't want to misrepresent what is in the record. There was also other evidence in the case. I don't know that the entire case against Mr. Perez went in front of this jury. So again, I can't speak exactly as to the basis of his plea.
But I guess it goes to Justice Budd's question, which is, best I can tell, everything he said was exculpatory to him as to what happened. I just happened to be in the car. They came out and they shot him, and I had no clue, no warning. I did nothing to assist.
Your Honor, he did indicate he was in the car. He did indicate he heard the defendant, Mr. Lopez saying to the defendant, shoot him, while the victim was in the convenience store. And then when the victim came back to the car, the victim wanted to smoke a cigarette. Mr. Perez told him not to. I believe after that, there was another stop at another convenience store again after hearing the discussion of shoot him. So I suggest that that is enough to suggest an accessory after the fact. Then later on, when they get back to Rhode Island, Mr. Perez is present again at Mr. Lopez's house, where Mr. De Leon shows up and takes the bullets and the gun from them. And then later, when he's contacted by police, says, I don't know who you're talking about.
So is Mr. Kenley right that for all practical purposes, where there is a plea and where the defense counsel makes some noises about there being a plea deal which could affect someone's testimony, that opens the door to prior consistent?
Not in all cases, Your Honor. I think it would be very fact-specific as to which case it would open the door. Again, here, this witness was challenged with other statements he made to police, and it wasn't just the mere fact of the plea arrangement, it was the other challenges made to this witness's statements to police.
And how much came in?
How much?
How much came in on the prior consistent? I'm sorry.
Trooper Russell testified in substance to much of the discussion on December 6th with Mr. Perez. The judge did give an instruction immediately before the trooper testified, and again in her final charge, she again instructed jurors as to the limited purpose of this testimony of the trooper.
So it sounds as if more came in on prior consistent than we would have allowed for first complaint.
I hadn't thought of it that way, Your Honor, but I don't believe so, Your Honor. I would have to look at it again side by side. I don't believe it was more than would have come in on first complaint.
So let me take a shot at Mr. Morales' theory here, okay, and see what you have to say. Prosecutor did absolutely nothing wrong under Ciampa in those cases about bringing up the written plea agreement during the opening and in direct. Nothing wrong with that. The defendant's cross really didn't do much more, only incrementally more perhaps, than what the prosecutor brought up. The the witness, Mr. Perez, sure, gave a different statement earlier than the grand jury, but on December 7th, when he's talking to the police, as the chief just alluded to, he's exculpating himself. He's really, common sense, only has one reason to be telling the police what he did and what he was involved in, and that's hoping it's going to help him. And if you take all that together, Mr. Kelly's saying, well, that's just not enough, and there's a substantial likelihood of a miscarriage of justice as to how the prior consistent statement was handled. That's the argument in a nutshell. And why isn't that right?
Your Honor, I would suggest it's not a substantial likelihood of a miscarriage of justice. Certainly, there were strategic decisions made in this case. We're not entirely sure what they were based on the absence of any affidavit from trial counsel or proceedings in the court. But certainly here, the witness made a statement to police and said, I'm afraid I need protection from these individuals. He did not know what police were going to do with the information they had against him. They said, we can't make you a deal, we'll tell the district attorney, but that was the extent of it. So suggest here, if the defense had thought this shouldn't come in, they could have moved in limine to exclude it. There's other ways to approach it, and the approach was, again, to embrace the fact that there was a plea agreement and say, as counsel did in closing, this witness is tainted by this agreement he made with the government and don't believe his testimony. And again, it was the defendant's argument, I believe, was that Mr. Perez was actually the shooter, saying, don't believe his testimony, he did it. And here again, it was a prior consistent statement, and the jury was instructed twice correctly as to what limited use to make of this statement. To suggest the real issue was what did they make of Mr. Perez's credibility, and based on the verdict, it's clear that they did credit his testimony.
But if it's, if we go with Mr. Morales's view of the case, I still don't, obviously, it is helping himself. It's exculpatory to say, I didn't do it, I had nothing to do with it, prior to a plea agreement. So I don't understand why that's not helping himself. Why doesn't Perez saying, I didn't do it, I had nothing to do with it, exculpate himself?
He puts himself in the car, driving around.
Oh, he has to do that. I mean, a lot of people put him in the car.
Driving around with these individuals, trying to cash the money order, drug dealing, and again, the rule could be, I guess, that you don't get to introduce the prior consistent statement. I mean, I'm not sure that that would make a difference in this case, but the court could adopt a rule that prior consistent statements aren't admissible, but the current rule does allow them in these circumstances. If there were no further questions, I would rest on my brief, asking the court again to affirm the conviction for the murder of Carlito Gomez.
Great, thank you.
Thank you very much.